But this one, we will just share it with you then. If you would like to watch it later,
Okay.
like how you were speaking and yeah.
Okay.
No, you just need to make some like introduction. So welcome to the final, to the first hearing about the case. Who is the defendant? Who is applicant? Who are the introduce the judges, and then you will give the word to applicant. And
But I have to tell the real names of the judges or like their names.
then use their names.
Okay. So, I wasn't prepared for this.
So the only like then the moderation things during the hearings will be if you will just ask after each speech like if there are some comments.
Okay.
If one side would react to other, if not, then let's move to the next plea.
Okay, so we are.
That's all.
Okay, so we are the European Court of Justice, and the applicants are Bulgarian Energy Holding, Bulgar Transgas, and Bulgargas, and the defendants are the European Commission. So here we have the applicants, the defendants, and the applicants, and I don't know. I have to say who has to start.
Yeah.
Okay, so the applicants will start. So you have the word. There's like a formula to say.
Not really like you say basically right. Like
Yeah,
now I
okay.
give the word to
The floor.
the floor.
I leave the floor to the applicants.
Okay, so our first statement will be the following. Based on Article 263, which allows for annulment of European Union acts that violate European law, of the treaty function of the European Union, seek annulment of the Commission Decision C 2018-8806, final of 17th December 2018. We believe that it violates the European law, and we do not believe that we are in abuse of the dominant market positions. Yes, dominant market, as stated and given for proof in Article 102 of the TFEU, which addresses the abuse of dominant market positions. And we would like to request a cancellation to the fine that have been imposed on us, or with a reduction of the given fee.
Okay, so now I leave the floor to the defendants.
Thank you. Madam President, Your Excellencies, my name is Rafa Karavala, and together with my co-attorney Ivan Dunju, we shall be pleading on behalf of European Commission, just the defendant. I shall be elaborating the second and the third part of the plea, and my co-agent Ivan will continue with the fourth and first plea. And before the proceedings, please let me elaborate a bit on the background of the case. The gas company Orgas, jointly controlled by Gazprom until 2021, issued a complaint directed at the applicants BEH and Bulgargas, and later, at the time of the infringement, the Bulgargas and BHE was the main importer of Russian gas into Bulgaria, the public gas supplier of the Bulgarian market, and the holder of an executive right. And we would like to emphasize this, that they were a holder of executive right of Romanian gas pipeline. And within this context, according to Orgas, both of the holding companies and their infrastructure, Bulgar Transgas, were sanctioned for a refusal to grant access in violation of the Article 102 of the Treaty of Functioning of the European Union. So, within all this stated, I would like to also summarize our pleas, but I don't know about your excellencies if you want to hear the applicants first.
Okay, thank you. I would say that we have the second plea.
Okay. So our first plea we're going to start with is that the Commission has failed to state reasons and errors of law and of fact concerning the definition of the market for capacity services on Romania pipeline number 1. In our opinion, the contested decision is vitiated by an inadequate statement of reasons concerning the definition of the market for capacity services on the Romanian pipeline 1, because the Commission did not explain why it had departed from its decision-making practice. According to that practice, gas transmission networks are natural monopolies generally having a national scope, in which the dominant service provider is the TCO. However, in our case, the Commission carved out an isolated section of the Romanian gas transmission network, namely the Romanian Pipeline 1 and the capacity services provided on that pipeline, as constituting a separate market, and attributed control over that market to the user of that pipeline, namely Bulgargas. We claim that by refusing to consult Transgas and the National Energy Regulatory Authority, the Romanian regulator, concerning the definition of the market for capacity services on the Romanian Pipeline 1, the Commission did not carry out the market analysis in accordance with the requirements of point 33 of the notice on the definition of relevant market for the purposes of community competition law. In our opinion, the definition of the market for capacity services on the Romanian Pipeline 1 is vitiated by an error of law, in that the Commission failed to distinguish between the primary and secondary capacity markets on the Romanian Pipeline 1. A first error in the assessment of the facts, in that the Commission did not identify Transgas as being the supplier of capacity-related services on the Romanian Pipeline 1. A second error in the assessment of the facts, in that the Commission identified Bulgargas as being a supplier of capacity on the pipeline and not as being a buyer. Regulation number 715 from 2009 of the European Union, of the European Parliament and of the Council of 13 July 2009 on conditions for access to the natural gas transmission networks and repealing regulation number 1775 from 2005 distinguishes between primary and secondary gas capacity markets. We state that under that regulation, only the TCO may sell capacity on the primary market, whereas network users may only resell capacity on the secondary market. Thus, by failing to distinguish between primary and secondary gas capacity markets, the Commission first erred in law by adopting a definition of the market for capacity services on the Romanian Pipeline 1 that was contrary to Regulation number 715 from 2009, and second, disregarded the fact that Transgas was supplier on that primary market. Bulgargas was merely a buyer of capacity services on the Romanian Pipeline 1 on the primary market for those services and not the supplier of those services. Thank you.
Okay, so I leave the floor to the defendants.
Thank you, Your Excellencies. I would like to react on what everything just said, and that I shall elaborate on the second part of the plea. The first part of our plea is alleging an inadequate statement of reasons for the definition of the market for capacity services in the Romanian pipeline. And Your Excellencies, we truly believe that in those circumstances mentioned above in the background of the case, the applicant cannot claim that the definition of the market for the capacity services of the Romanian pipeline is not supported by sufficient reasoning, on the ground that the decision cited by the Commission concerns owners of gas transmission network and not the users of those network. In this background, we believe that it's inevitable to cite the Article 102. And this article says that any abuse by one or more undertaking of a dominant position within the internal market or in a substantial part of it shall be prohibited as an incompatible with the internal market insofar as it may affect the trade between member states. This abuse may consist, for example, in limiting production, directly or indirectly imposing unfair purchase, and so on. The Commission thus sees the factual situation being similar or almost the same to this article, because BH and Bulgargas have a dominant position in the market, and there is truly a limitation to the Romanian market, because how can other gas companies or excellencies have the same right to access this market? it's almost impossible for them. Now I would like to elaborate on the second part, alleging the failure to analyze the market for capacity services in the Romanian pipeline. The applicants submit that by refusing the consult Transgas in Romania concerning the definition of the market capacity, the Commission did not carry out the market analysis in accordance with the requirement. In that regard, it should be noted that contrary to the applicant's explanation, the Commission carried out a consultation in order to define market. The Commission will often contact the main customers and main companies in the industries, and the Commission did this in our case. Therefore, Your Excellencies, we believe that this part of what applicant was claiming must be rejected. And now, allow me to move on to the third part, as applicant stated, alleging errors of law and errors in the assessment of the fact in the definition of the market and services on the Romanian pipelines. Accordingly, the complaints alleging that the Commission erred in law by failing to distinguish between the primary and secondary capacity markets of Romanian pipeline law, and alleging that the Commission made an error of assessment by failing to identify Transgas as being a supplier of those capacities, must be rejected, because, Your Excellencies, as we saw in the background, the Commission was acting within their scope, and it did everything to prove that the Article 101 was breached. And now, please let me to sum up my pleading that the Commission does not see the factual situation. The Commission does see the factual situation of this case being similar or the same to the Article 102, and the BEH and Bulgaria have a dominant position in the market. But there is a limitation to the Romanian market because, as we stated in the beginning, other gas companies do not have the same right to access the market within the scope of the skill and competence. And this concludes my pleading. Thank you, Your Excellencies.
Thank you. So, do the applicants want to reply something?
We don't have any questions.
So, basically, now we have to say what we think of the first layer, or we have to go on and then give our judgment about that at the end.
If you have something, you can also ask them the questions now.
Okay. Can we have like 5 minutes when we talk with each other about the questions to them?
And you can also discuss with yourself if you would like to
Okay,
react
so-
on something on what they said and you.
Which questions do we like to give to them? It's the first one. The first one is later. So it's the second. See, I think sì, no. The second player. Sì, cioè adesso. Ok. So which questions would we like to ask them? Here. So maybe
Yes, but like basically it's the same rules and ways, and they gave arguments about this. But we see the second one. Yes. No, the second one basically. Yeah, they were.
sorry, nothing.
Yeah, because it's the way he started the second week, in the first place at the end, so that's why we gave him the second position and we're going to the third. We asked some applicants, and so this is the reaction of the applicants.
Why we still want
So, decision of commission, we are against And there is the result is like
It was
the
this.
number
It was the one.
Should be
the
reviewed.
same thing. It doesn't matter. Like it's the contest is the same. It's the same. Like it's just
Maybe I ask. Okay, so first I ask
this one. This one. I think
Cioè, siamo partiti così a
yeah.
caso.
This one. This one. So in December, you had it in this December. Yeah, that's yeah. It's like basically here you have 1, 2, 3, 4, and they have their own
Magari possiamo chiedere alla Commissione why they how they calculate
treaty of
Functioning. Okay. Okay.
Loro vogliono una isolamento dove siamo giustamente insieme a questi la riduzione
It's transfer between transfer and Bulgaria. They did this agreement in the year 2005. So if they call it judgment,
do you know what sentence is about the station
yeah, wait. Here.
maybe we can like for
in
a
case I would say
Yes, of the Romanian platform.
the motivations of
And Bulgaria was paid to have it fixed.
and another one that is
Not purchased, but yeah. But they have it in the I guess I don't know. I just don't understand energetic stuff.
se no
I kind of
sì, o se no in base alla
Io can ask why the application is not identified as
myself.
being
I like human rights.
but
then the connection is interesting. What is ETN? More legal term? Like what are the motives
Have the computer.
the motives for
Now we're doing it. Okay.
not to identify trans gas.
si può dire you alla commission
Perché non esiste c'è la
European free trade.
Do you need more time?
Yeah, like 1 minute.
Economic area. Sorry.
Why you defenders haven't
identify.
Yeah, that I know what it is. EU members and also like Iceland.
That's
Yeah,
the
because they're not in
supplier of
Sì.
the European Union, but they have this agreement.
dove sta utilizzando
I know it's not.
maybe
Which were
being
it's just one
supplied
of
to
the
the
article
primary market of the
No, it's the decision, the case. They did the decision and we are against the decision. So called contest.
So the final decision, but we already
I think that the time Overgas had complained on us and commission decided to do and we now are complying against commission decision. And no, commission was wrong. So the decision that they make right Overgas and about us is contested parameters and they call it contested decision because it's like no, it's just like the decision is it we talk about. I don't know. The ones, the middle article
Is taking role, we are opposing the
commission the decision but this is not the importance of our but
I didn't understand what
maybe the decision about invitation to
which means business first to do the first part. Let's
I think that's
she doesn't
yeah,
want to
no, text is like state to state. When you work, you can state. That's text.
Oh, tax.
Text. TAX.
Yes.
No, it's TAX.
For the no, for the can the defendant give us more information about the implementation of about the implementation?
They can ask each other as well.
She has to.
The president has to ask the question
It can be any of you. It doesn't need to be only the
Okay.
president. They are all judges, so any of you can ask the questions.
But she has the one to.
No, it's not necessary.